Welcome, listeners. My name is Diana Bernard and I'm the Manager of Education at Seniors' Rights. This video today is about wills and estates, and I'm in conversation with one of our lawyers at Seniors' Rights, Tim Tunbridge. Welcome, Tim.
Thank you, Diana.
So perhaps you could just begin by talking a little bit about what the legal service at Seniors' Rights does.
Yes, thank you. We are a community legal centre and we provide free legal advice to people over the age of 65. One of the most common areas of law that we're asked to advise about is wills and deceased estates. We also advise about a broad range of other areas of civil law, not criminal matters.
Okay. And we also, I believe, do some work around retirement villages and strata issues.
Yes, one of my colleagues specialises in retirement village law and also in issues relating to strata law.
Terrific. So, first of all, a question many people might ask is, can I buy a will kit and write my own will? Is that a good idea?
That's a question we're often asked. I would say that's not recommended for a couple of reasons. Firstly, wills are an important document that need to be correctly worded in language which is unambiguous. And it's important that also that wills are properly signed and witnessed, which is a factor that needs to be complied with under the Succession Act, which is the relevant law. The case study of the late Brett Whiteley, who was a famous Australian artist. I believe you're familiar with the case.
I am.
And Mr. Whiteley didn't believe in lawyers. He believed in writing out his own will, even though he had a very large estate of about $20 million. And on one evening, he got together with his daughter and the daughter's boyfriend around the kitchen table, and he wrote out a handwritten will in which he left some legacies to different people, but most of his estate went to his daughter, a young lady called Archie. Now, Archie was one of the witnesses to the will, and also Archie's boyfriend, a young man called Christopher, also witnessed the will. One of the problems with that was that the gift to Archie would then have failed because she was a beneficiary and also a witness to the will. So Mr. Whiteley obviously was unaware of that. And as it transpired, Mr. Whiteley then lost that will and he decided to make another one. So again, he was sat at the kitchen table, this time only with Christopher, and he wrote out the will and Christopher signed it. And then he decided, for reasons best known to Mr. Whiteley, to pin that document to the kitchen drawer or the underside of the kitchen drawer. Anyway, when Mr. Whiteley passed away, no one could find the will. And there was a big case in the Supreme Court involving many barristers and senior barristers to decide on the issue of what was Mr. Whiteley's last will and testament. So it would have been much easier and cheaper if Mr. Whiteley had in fact seen a solicitor and had the will properly prepared and executed.
Oh, so if I didn't have very many assets, is there any point in me doing a will?
Well, one of the main things about making a will is that you may direct your executor as to how your assets are to be disposed of. And you might have a specific family heirloom that you want to leave to a particular person. You can do that. Or you may have a specific wish about how you want your remains to be disposed of.
Oh, okay.
You might have some wish which you can direct your executor to carry out.
So, Tim, if my will's 20 years old and I've remarried, do I need to change my will, or is it okay as it is?
Well, usually a marriage will revoke a former will, so it would be very advisable to make another will, particularly if a will is 20 years old. It's advisable to review one's will every 5 to 10 years to make sure it's up to date and it really is what you want. It complies with your intentions.
Well, okay, that makes sense. So what happens if a family member that I haven't seen for 20 years tries to make a claim?
Well, if a family member, usually an adult child, wants to make a claim against your estate, then you can't stop them making a claim because they would be an eligible person. The best thing to do would be, at the time you make your will, is to make a separate statement giving the reasons why that adult child has been left out of the will. Usually reasons might include the fact that you've made generous provision already during your lifetime to that person, or alternatively there may be an estrangement, so that you may have not seen the adult child for many years, and the statement can give details about the circumstances of the estrangement, what attempts have been made at reconciliation, and in that way the executor of your estate may use that statement in order to defend the claim after you pass away.
Okay, thanks for that. Actually, it might be useful for you to explain the role of an executor, if you could.
Yes. An executor is someone who is named in the will, and the job of the executor is to get in or collect the assets of the estate, to pay the debts, and then to distribute the estate in accordance with the terms of the will. What the executor has to do is make an application to the Supreme Court for a grant of probate. The word probate means that the court will make an order approving the validity of the will. And once the court order is made, then the executor has the legal authority to administer the estate.
Okay, thank you. And is the executor usually told that they're the executor?
What would normally happen is the person, when making their will, would ask someone if they're willing to act as an executor.
Yeah.
That doesn't always happen, but an executor may find out that they have been appointed when they receive a copy of the will after the person dies. And
so
at that
could
point,
come as a shock.
it could. At that point, the executor, of course, could renounce their appointment and say they don't want to do the job, in which case there would need to be another person appointed to act as the executor.
Okay. And what happens if someone dies without a will?
Well, in that circumstance, someone, usually a close relative, would apply again to the Supreme Court to be appointed as an administrator of the estate. And the powers of the administrator are set out in the Succession Act, and the estate would be distributed in accordance with the rules set out.
What happens if my child has inherited the family home and I've been asked to move out by my children?
Regrettably, that's a very sad circumstance, which sometimes happens. But the spouse of a deceased person is eligible to bring what's called a family provision claim. That claim must be made to the Supreme Court within 12 months of the date of death. And the spouse has rights to ask the court to say, look, I have been left without adequate provision for my proper maintenance and advancement in life, and therefore an order should be made from the deceased estate. An interesting case study that we did involved a widow who was in a de facto relationship with a man for about 15 years before he died. She cared for him for about 5 years in poor health before he died. And when her de facto partner died, the will, well, in fact, in her case, there was no will. So the only property which the deceased de facto partner had was a house where they'd lived, but that house was in the joint names of the deceased and the deceased son from a previous marriage.
Oh dear.
So when the deceased passed away, the house, the ownership of the house, became entirely owned by the son from the previous marriage. So he said to the de facto partner, "Look, it's my house now. I want you to leave." So the widow, with our assistance, was able to bring proceedings in the Supreme Court within the time limit of 12 months to claim a share of the estate. And because the widow was in poor circumstances and the son was a fairly wealthy individual, she was successful in getting a half share of the house. We did ask the court to make what's called a notional estates order, which means that the half share of the house which went to the son really should have gone as part of the deceased's estate and be available for a family provision order. So at least the widow was able to get a half share of the house and to have some money in order to provide for her future accommodation.
Oh, well, I'm glad to hear that. That sounds awful. So, Tim, what's the best way for people to contact the legal service at Seniors' Rights?
We have a contact number, which I think you might be telling everybody about shortly.
I will at the end, yeah.
So the procedure is to ring up and to make an appointment to speak to one of our lawyers and to give for legal advice. And we'd be happy to provide that.
Thank you, Tim, for that information. And thank you, listeners. And don't forget that number is 1800 424 079 if you'd like to ring our legal team or get any more information. You might also like to look at our website, which is on the screen at the moment. And on the front page, there's an information toolbox. There's lots of information in there on other legal issues and also on some advocacy issues in case you'd like to have a look. Thank you again.